Hi, Bill Henshaw here again, another one of my YouTube current events videos. And this is part three on the subject of they don't want to go to trial. I've just done recent videos, and you think I'd get it right the first time, like it says on my business cards. I don't practice law, I get it right the first time. Another big deal here, and it hasn't come up yet and probably won't, but think about this. Because if you do go to trial and get convicted, and especially if your bleeping defense attorney has offered a plea deal and you've refused it. Now you go in front of a jury, and I have a situation I'm aware of in the Midwest where the person correctly turned down a 4-year plea deal for having done nothing wrong at all, went to a jury and got convicted, is now serving 8 years, a situation I am trying to correct. Think about that. In effect, what that does is penalize you for invoking a right secured by the Constitution and more than one right, but here in particular, the right to have a trial by jury. And you're going to get, nailed with double the amount of time or the maximum amount of time, which could be even a lot worse. And in fact, in a recent case in Louisiana, it just had a guy got out of jail after being there for 8 years, having gotten a life sentence. Are you ready for this? As a repeat offender, quote unquote, for having sold $20 worth of marijuana. What the hell is going on here? And defense attorneys don't get this. Black robe bastards don't understand it. Your local dumbass doesn't understand it. No, it can't be that way. They all know better than this, and what we want to do is make them pay and stop doing it. So we have a major issue there to start with. Number two, if you use the issues that I advocate, and I've got a number of unopposed issues, send me an email, youwinnincourt@gmail.com. You're going to love it. And I'll send you info on what I have, my modestly priced constitutional defense document packets. And the way I do things, every issue I raise, every one of them, and they're all unopposed, challenges what I call the malignant, malevolent monopoly of the State Bar Association on the practice of law, and it challenges their very existence. Now, this situation arose in a local felony case where I wasn't directly involved, but I handled quite a lot of it. And the assistant DA was very, very off-putting to me, condescending, demeaning, like these bastards think they are. They think you don't know all the law, and the hell with you. And the problem is they're dealing with someone that's forgotten more law than they'll ever know. Ended up that they didn't go to trial either. If they had, this second issue would have arisen because now, having made these challenges and being compelled, as it were, at the moment, to have them ruled on by State Bar Association member judges, where in the world can we find what the Supreme Court has mandated, even under the BS 14th War Amendment, to be neutral magistrates? They have irreconcilable conflicts with rights secured by the Constitution, and particularly in view of the practice of law that's enjoyed by the state bar. Therefore, they can't be a neutral magistrate. They don't exercise the judicial power of the United States in any case. And now you have no one sitting there that can make a ruling on it, except for the fact that with the right to trial by jury according to the course of the common law, which inhabitants of territories have pursuant to the Northwest Ordinance of 1787, but is somehow nowhere in sight for lawful de jure jus sanguinis state citizens and a lot of other people that are residents in quote unquote states, also known as being resident in the District of Columbia, a video for another day. How in the world, can we get any neutral ruling on this unless we go to a jury? And then only unless our jury instructions get in there. And I've had cases in which my almost 600 jury instructions have been denied by a black robe bastard at the stroke of a pen with no opposition from the local dumbass. Where is the neutral magistrate here? If we can't present our theory of the case to the jury, and the jury here, by the way, the U.S. Supreme Court says, and the Constitution mandates, has the power to rule on the facts and the law. That's the great protection we've had with trial by jury going back 800 years to the Magna Carta in 1215. Where the fuck is it today? I'd love to see it. So that said, with all these conflicts of interest, you can't have anybody that's a state bar member that has any business sitting in a judicial court, most particularly, but even in one of their corrupt courts and making rulings on issues like this. And that's one of the biggest edges that we have in our favor is they can't do it. And if they do it and do it on the record, now this but the Supreme Court calls it what it is, not me saying it. Treason to the Constitution, exercising a jurisdiction you don't have, and at the same time refusing to exercise the jurisdiction with which the court is vested. That's how we get around these bastards. How many of them it takes to go to jail, I don't know. I'm working on this. It's a novel approach I've developed, but I don't. If we have a constitution, it can't lose. It's all there. I'm taking the Supreme Court at their own word from a lot of what people say are vintage opinions, overruled by the non-existent 14th War Amendment, which isn't possible since the amendment itself doesn't exist. And I've got a brief on that you get with my document packets. Send me an email, youwinnincourt@gmail.com. The ratification with a capital RAT of that amendment violated all 6 articles of the Constitution, and the 9 parts contemporaneously ruled it unconstitutional. If you know what it is you're reading. And yet that's the only jurisdiction these bastards exercise. Traffic court, family court, tax court, probate court, you name it. That's all they have. You see the magnitude of the problem here? So that's what I should have said in part one of this discussion, about the fact they don't want to go to trial. Now you get a real idea of why they don't want to do it, because if this stuff gets on the record, even in one case, the decision is good. And for example, it would eliminate every mortgage from Portland, Maine to Portland, Oregon. Simple. And on the money issue, and no one knows more about that issue than I do, undefined dollars. So that's a video for another day. In any case, I think I finally finished here now on why they don't want to go to trial, and we should. And you get a clear idea of why that's true. So the upshot of all this BS is that everything I said is true, and not only will they think they have the power, the local black robe bastard, the local dumbass, to dish out the maximum sentence. Who knows what additional conditions they can put on anybody they throw in jail under circumstances like this? And they think they can do it because there isn't a damn thing we can do about it. They have all the power and we have none. That's exactly the reverse of what the situation really is. And it's my goal to get that changed as quickly as I can. Whether I live to see it or not, I don't know. I got 8 or 10 good years here if all goes well. But we're the ones that have the power, not them. There's no voluntary knowing and intelligent waiver of rights here. There's no voluntary agreement into the system, which is what they think you do when you get a social insecurity number or one of their damn licenses. By the way, note the definition of license, Black Law Dictionary, 4th edition. Permission granted by competent authority to do an act that without such permission would be illegal, a trespass or a tort. Now, we are in a principal and agent relationship with government. Since when do we need our agents' permission to do anything? Think about that. But that's one of the net effects of the damn 14th War Amendment, is to have reversed it, and without telling anybody who ratified the amendment that that's what was happening. So now we go from principal and agent to what they ingeniously maintain is guardian and ward, but with what is really master and slave, just like the antebellum period in the South. It's exactly what we have now, and none of us have any rights that the de facto National Socialist government is bound to respect. Not a one, including the fact that the IRS operates on the principle, quote unquote, that a taxpayer has a zero interest in his time and labor. You have no property rights to your life, and yet with the Declaration of Independence, we became the only nation based on the principles that men have right to life, liberty, and pursuit of happiness. What the hell changed here? Maybe you can answer that question. I'd love to hear it. Meanwhile, for more information, send me email at uwinningcourt@gmail.com about my materials and what I do. And remember to like the videos, subscribe, tell your friends, get the word out. The quicker we all work together across the spectrum, Americans, Africans, and Asians, the quicker we get these bastards off our back. Thank you.